Discharge of a contract. Discharge of a contract means the termination of the contractual obligations between the parties where they are released from further performance. A contract can be discharged through performance, frustration, or breach of contract. Discharge through performance. Discharge through performance means that both parties have fully and exactly carried out their contractual obligations. The exceptions to this are tender of performance, severable contracts, substantial performance, acceptance of partial performance, and delayed performance. Tender of performance means that one party has offered to perform their obligations but the other party refuses to accept that performance, as shown in Startup v. McDonald. Severable contracts mean that a contract is divided into separate parts where payment is due for each completed part, as shown in Honig v. Isaacs. Substantial performance means that a party has completed most of their contractual obligations and may claim the contract price, minus the cost of defects, as shown in Honig v. Isaacs. Acceptance of partial performance means that one party freely accepts incomplete performance, and they must pay a reasonable sum for the work done, as shown in Sumpter v. Hedges. Delayed performance means that performance is carried out later than agreed and may lead to a breach where time is of the essence, as shown in Bunge Corporation v. Tradeax Export SA. Discharge by frustration. Discharge by frustration means that a contract is automatically terminated where an unforeseen event occurs with neither party at fault, making the performance of the contractual duties impossible, illegal, or radically different from what was agreed to. Grounds for frustration. The grounds for claiming frustration are impossibility, illegality, and a radical change in obligation. Impossibility means that the performance of the contractual duties become physically or legally impossible due to the destruction of the subject matter or the unavailability of an essential element, as shown in Taylor v. Caldwell. Illegality means that performance becomes unlawful after the contract has been formed due to a change in the law or circumstances, as shown in Metropolitan Water Board v. Dick Kerr & Co. Limited. A radical change in obligation means that the event transforms the nature of the contractual obligation so that they are fundamentally different from what was originally agreed, as shown in Davis Contractors Limited v. Fairham UDC. Limits to frustration. The limits to frustration are self-induced frustration, foreseeability, and mere hardship or increased expense. Self-induced frustration means that a party cannot rely on frustration where the frustrating event was caused by their own choice or fault, as shown in the Super Servant 2. Foreseeability means that frustration will not apply where the event was foreseeable and could have been provided for within the contract, as shown in the Eugenia. Mere hardship or increased expense means that frustration does not apply simply because performance has become more difficult or costly, as shown in Davis Contractors Limited v. Fairham UDC. Consequences of a frustrated contract. The consequences of a contract being frustrated are that it is automatically discharged when the frustrating event occurs, so the parties are released from further future obligations. Money paid before the frustrating event is recoverable and money due before the event no longer needs to be paid. This is subject to the court's discretion to allow a party to retain or recover expenses. A party who has provided a valuable benefit before the contract was frustrated may be entitled to receive a reasonable payment for that benefit, as shown in Fibrosa Spolker Axina v. Fairbairn Lawson Coombe Barber Limited. Breach of a contract. A breach of contract is a failure by one party to perform their contractual obligations without lawful excuse. The different types of breaches are actual breaches, repudiatory breaches, non-repudiatory breaches, and anticipatory breaches. Actual breach. An actual breach occurs at the time the performance of the contractual duty is due, as shown in the case of Bolton v. Mahadeva. The consequences of an actual breach are that the innocent party may claim damages and, if the breach is sufficiently serious, may also terminate the contract, as shown in Poussard v. Spires. Repudiatory breach. A repudiatory breach is a serious breach that goes to the root of the contract and allows the innocent party to terminate the contract and claim damages, as shown in the case of Hong Kong Fur Shipping Co. Limited v. Kawasaki Kisen-Kaisha Limited. The damages that can be awarded for a repudiatory breach are compensatory damages designed to place the innocent party in the position they would have been in had the contract been properly performed. A repudiatory breach of a condition occurs where a fundamental term of the contract is broken, giving the innocent party the right to terminate and claim damages. A repudiatory breach of an innominate term occurs where the effect of the breach deprives the innocent party of the benefit of the contract, allowing termination and damages. A repudiatory breach of a warranty would not usually arise because a warranty is a minor term, but if it were classified as repudiatory due to its consequences, it would allow termination and damages. Non-repudiatory breach. A non-repudiatory breach is a breach that does not go to the root of the contract and therefore only gives rise to a claim for damages, as shown in the cases of Bettini v. Jai and Bolton v. Mahadeva. The damages that can be awarded for a non-repudiatory breach are compensatory damages to cover the loss suffered, without the right to terminate the contract. A non-repudiatory breach of a condition would arise if the innocent party chose to continue the contract despite the breach, limiting their remedy to damages. A non-repudiatory breach of an innominate term occurs where the consequences of the breach do not deprive the innocent party of the whole benefit of the contract, so only damages are available. A non-repudiatory breach of a warranty occurs where a minor term is broken, and the innocent party is entitled only to claim damages. Anticipatory breach. An anticipatory breach is a breach that occurs before performance is due, and one party clearly indicates that they will not perform their contractual obligations, as shown in the case of Hoekstra v. de la Tour. The nature of an anticipatory breach is that it occurs through words or conduct, showing an intention not to be bound by the contract. The choices that the other party has are to accept the breach and terminate the contract immediately while claiming damages, or to continue the contract and wait until the time for performance. Thank you for watching this video on discharge of a contract. I'll see you in the next one.